All right, you just put 3% down on a house and put that into escrow. Now you're wondering, holy smokes, there's so much wrong with this house. What if I cancel my contract? What's going to happen with my deposit? Who gets that money? Well, I'm going to explain that to you real quick, looking from both the buyer's angle and the seller's angle so you can understand what's happening, because we're going to start out understanding what the deposit is. The deposit is something you put down or put into place that goes into escrow, that sits in escrow until you close, and then if you do close, that money gets put towards your loan, basically. Well, in California, there's something called liquidated damages. And liquidated damages is usually good for up to 3% of the purchase price. And so most people in California are putting a 3% deposit into escrow. So that would be if you bought an $800,000 house, you put a $24,000 deposit into escrow. But what happens if you cancel the escrow? Where does that money go? This is the tricky part. If you have all of your contingencies in place, what are the contingencies? Your inspections, your loan contingency, the appraisal contingency. If all of those are in place, you have not filled out the form, the contingency removal form, to remove those items, and you cancel escrow, you would get that deposit back generally. No questions asked. Usually it has to come back to you within, I think it's within 72 hours. If it's not given back to you, then it's being held. The seller could be liable for a penalty if they don't give that money back to you. If you remove your contingencies, all your contingencies, again, your inspections, your loan, your appraisal contingencies, you've signed a contingency removal form saying that you understand that you're removing all your contingencies. If you remove all your contingencies, and let's say on day 28 of a 30-day escrow, you decide, I don't want this house anymore, the seller could keep up to 3% of the purchase price no matter what your deposit is, but you have to agree to release that deposit to them. So here's where it gets tricky. If you've removed all your contingencies and you want to still try to keep your deposit, you've probably signed or initialed a box for mediation and arbitration, which means you're going to go in front of an arbitrator or a mediator, and they're going to look at the case, they're going to look at the paperwork, and they're going to say, hey, you initialed liquidated damages here, and you initiated or initialed mediation and arbitration here, you're going to lose your deposit. And you're going to pay for all these fees that it costs to go through this process. Or a lot of times what happens is that if you do cancel or try to cancel escrow after you removed all your contingencies, if I'm your agent on my side, I go to the listing agent, talk to them and say, hey, here's why they're canceling. If it's a legitimate reason, maybe you lost your job, death in the family, maybe you found out something about this property that wasn't there before, honestly, maybe the seller didn't disclose. That's something possibly you could sue for later. But if there was a true hardship, a lot of times the seller will let you out of that contract. Not always, not always. I don't want to say a lot of times. I guess sometimes that's happened. I've had clients on the listing side that have given people their deposit back, understanding the hardship that that buyer has and giving them that deposit back, even if they canceled late into the process. But on the other end, I've had sellers that haven't given that money back because they feel that honestly they're being jerked around a little bit by the buyer and they kept their deposits. So that's something you need to know before you sign the line and put your deposit in, because technically escrow is not opened until that deposit goes in, which is usually due within 72 hours, sometimes in 24 hours. But once that deposit's in, we're off and running, and your agent, hopefully it's agent B, is giving you and talking to you about your timelines, your liabilities, and trying to make sure they protect you through the process so you understand and you have those conversations that, hey, we're about to remove all of our contingencies and this is what it means. Okay? So hopefully that answers your questions. If you have any other questions other than this, contingency removals, deposits, those type of things, I can certainly ask those for you. Please DM me, reach out to me. All my information's right there. I hope to hear from you. I'll talk to you soon.